say with also what I've noticed is that when employees come to you once they've been dismissed, then they want to backtrack everything the company has done. But you didn't even open one grievance. Went through how much money he gives me. Yes. Because now we are trying to justify if there's any money coming in that you probably didn't declare. Believe it or not, before I was dismissed, I had dreamt something about that, but I didn't understand it. So when it happened after a few months, I was like, Father God, you're being unfair. Like, all I do is assist. I've never done anything. What's happening? And through that, then eventually when I was going through suspension, being dismissed for TikTok, then it was a thing of, I don't think I actually dealt with the dismissal then, because then I was having people saying, listen, I'm in Durban, come represent me. Currently, I am in my third year of my LLB.
Good day, everyone. Welcome to the Sisol Workforce Talk. I'm your host, Solomon Makhobatlo, and I'm here today with I'm actually excited because you can see the guest is already smiling. The conversations that we had off record were super interesting, and I think we're going to share, insightful insight to all our listeners, whether you are on Facebook, you are on YouTube, you are on podcast. We're here to talk about workforce stuff. We're here to talk about leadership. We're here to talk about industries and the economy at large in South Africa. Funny enough, we're sitting here today on it's the 9th, right? On the 9th.
It is the 9th, yes.
of June, 2026, with one of the media's publishing and talking about an employee who passed away. May her soul rest in peace. At a company, I wouldn't mention the name of the company, but yeah, I'm sure you know what I'm talking about. So my guest, her name is Wendy Mosuoe. I got the surname quite right.
You did. On record, you did.
Thank you, Wendy. Wendy, welcome to the Sisol Workforce Talk. I'm super excited to have you here.
Thank you so much for having me. I'm very honored.
Great. Wendy, off record, I did say we did chat a little bit just to get to know each other a little bit. Previously I interviewed quite a number of people that I have interacted with before, and I'm glad this is going to be our first interaction, and already it's like on fire. You get what I'm saying? Based on what you do, I think my media team invited you because your reputation, I think it precedes you. Social media, helping people. With regards to dismissals and labor law on its own. But I don't want to be the one taking the spotlight here.
Okay.
Can you please share with us who is Wendy Mosuoe? Where are you from? What did you study? And how did you end up doing what you do?
Okay. So I was born and bred in the Vaal Triangle. So I'm from the Vaal Triangle.
Yeah.
I'm currently based in Pretoria. So I don't think I had an easy upbringing in terms of things coming easy. But one thing I'm grateful for is that if there was a gray area, I was going to explore it, right? Yeah, so in terms of studies, I currently only have a paralegal. And currently I am in my third year of my LLB.
Congratulations.
Thank you. But if I can tell you that the grays I've already explored, I don't know if it's worth it or not, but we'll see. So I started my career as an HR consultant, HRIR consultant. So that's where you sit, the employer side, representing employers, assisting employers. And from then on, because obviously I'd only see the back end, which is obviously your CCMA. I did not know the processes. I did not know how Department of Labor works, how does UIF work. So from then on, COVID hit and I was retrenched and I was like, okay, how about maybe then I explore HR? Let's see. So that's when I tapped into HR officer, and I think I've been with quite a few companies. And then up until my last company last year, I was then the head of department of HR, sitting actually here in Riverfields. Yes. Sitting
Nice.
in Riverfields, one of the 26 companies under ShopRite. So yes, I was with Freshmark. So I think there, apart from my entire career, politics will always be there. And I think how I experienced it last year was very severe, to the point that I made a choice that I'm never going back to employment. Yes. And I remember just before I was dismissed, actually, I remember there was sort of like if I can say, a development course that I was selected to be part of, a leadership course.
Nice.
And I had to go to my manager and ask him, what are my weaknesses, what are my strengths? And he was like, no, everything is fine. The only problem I have is that you are actually too much on the side of employees, And I didn't understand it, but now that I sit here today, I'm like, I see what he meant.
Right?
Not really shop steward. You're an HR, but you're like, no. I understand you're the manager. Bring the employee in so I can hear the employee's side, And in certain instances, I believe I was an HR that would say, this is simple, can't you go out on a Friday, squash it, because it really doesn't deserve a warning, There's certain things that are really just minor, So apart from that, that's why I was seen as someone that was too much for employees, because for me, it needed to make sense. If I'm going to be going to the CCMA and representing the company, I don't want egg on my face to say, I don't know how we ended up here, Commissioner. Simply the manager didn't like the employee. No. So then from then on, before actually I was dismissed, in December, I think that's when TikTok, social media, and I was like, okay, one thing about me is I am a child of God, but I don't think my relationship with God is that strong that I can start content about that. I'm still growing, So what else can I do? Okay, I can't dance. I don't know how to sing. So I was like, okay, maybe let me share my expertise and see where it ends up, And I think my first video was I still like it till today. It was terrible, but, it had to do with the lines of...
Yeah, no, we all start somewhere.
we start somewhere,
Yeah.
That, okay, you've now bought the sick note, you've submitted it, I check it through the HPCSA and the doctor, and it's not valid. Do you go back and fetch your money, But it was a bit humorous, but yeah. So then from then on, I think I just kept on sharing, and, my audience grew. And within I could say overnight, I was very shocked actually to be like, is this me? What's happening? And through that, then eventually when I was going through suspension, being dismissed for TikTok, then it was a thing of, I don't think I actually dealt with the dismissal then, because then I was having people saying, listen, I'm in Durban, come represent me, I'll fly you through. Yes, that's literally what happened. I was also very shocked. I was like, okay, I don't know what's happening. I've never sat on that side of the table. I've always sat on this side, but let me explore and see. And the moment I tapped into that side, I think I've sat on this side just to know the tricks of the book, just so that I can represent quite well this side, So that's how I ended up then being the labor law lady on TikTok. And
guys, we're sitting literally with the labor law lady. Wow. You know what? It's exciting to really sit with somebody who started on the other side, my side.
Your side.
And then now you are on the other side.
Yes.
Literally, definitely, I agree with you that once you understand this side, you can even preempt the approach.
100%, because I know what you taught. I know that if you're going to start at 2, that, okay, maybe his maximum is 3,
Yeah.
So yes, 100%.
Wow. So you mentioned that you are a believer in God. And, I'm a Christian, and I think I'm a strong believer myself. And I think in life, something must guide a person. How did you find yourself as from retrenchment, and then now you want to start this, and then now you look at your relationship with your God, and that transition? How did that happen?
So that transition, first of all, was not easy, right? And that is why with every client that I deal with, I don't only assist professionally because I've been there and I know, so that sympathy goes a long way. So believe it or not, before I was dismissed, I had dreamt something about that, but I didn't understand it. So when it happened after a few months, I was like, Mara, Father God, you're being unfair. Like, all I do is assist. I've never done anything, you know?
Yeah.
So that switch was very difficult. And for me, I think about 2 months in, just after I started, because remember now I'm still dealing with being dismissed unfairly. I'm still fighting my own case. I'm fighting other people's cases. So I then had to 100% go into therapy. And that was to change the mindset, you know, to say, yes, this has happened. And I learned then that a dismissal is the same as a traumatic experience. I never knew. It's the same as getting into a car accident. It's the same.
We're traumatizing people?
Yes, 100%. Because just after I was dismissed, my sleeping habits were off. My eating habits were off. Like, there's just so much that goes into a simple dismissal, you know. So now back to being a child that really fears God, you know. It was very difficult because my conversations with God, my relationship with God then obviously changed because now I'm going through this traumatic experience, you know. And one thing about me, there's this thing that when things are good, you forget God, and when things are bad, you then go back to God. For me, I've always felt like it's the opposite way. When things are like good, I'm in sync with God. When things are bad, I'm like, I'm too depressed to even talk. I don't know what to say, you know. So with that, one thing that I definitely focused on was reminding myself on what I've been taught and what I can still do, because I didn't have the energy at that point. I'm dismissed. Now, all of a sudden, everything terrible that is happening in your life happens at that exact moment, you know? And you're still dealing then, obviously, with your reputation. That, I mean, I used to be a head of department. Now I'm dismissed for TikTok. Make it make sense. Of HR.
No, man.
Yes.
Please tell me about that.
Yeah.
Tell me about the process and
Yes.
the whatnots, and how did you end up defining the dismissal to be unfair, actually?
Okay, so the Freshmark was starting a new distribution center, right? Riverfields, I think since you are in this area, there's a section there when you're on the highway that they were still building, right? So from then on, I was then still with Soho, right? And what then transpired was they were starting a new distribution center and they were looking for external people if they could not fill it internally, right? So most of the department heads that I then started with and joined with were people that were already internal. They probably had maybe a mid position and they were now moving into a senior position since there's a new distribution center. So the Centurion branch was basically breaking and people were moving there, right? So then I was recruited, I was happy, head of department, not a problem. I'm a bit fearful because now I'm starting with a team and subordinates that already have their flow, and now I have to come. But it went smoothly. Absolutely love them. So from then on, there was one operations manager. You know.
There's always that one. Eh?
Yes. You know, and that was just not happy with how I do things. You know, so. I believe I'm a very firm person. You know, if I know what the law says, that's what we're going to follow. If that's how you did it in Cape Town, this is not Cape Town, you know. The law is like this because tomorrow I'm the one that's being questioned on how did we end up with this risk. Yeah.
And then what happened? Then were you taken through the process?
I was taken through the process. So before the process, there was an issue where we fought about my cell phone number, right? So a picker, which is basically a general worker, was like, you know, hi, Wendy, I can no longer move from Centurion to Riverfields. I had to move out of home because now I'm staying in Pretoria, so I'd like to still remain at the Centurion branch. And this is a day before we go live, so the day before we actually move and everything. So then I was like, okay, before I even address this, who gave you my number, you know? No, one of the operations assistants gave me your number, and I said, okay, hold on, I'll be back. Then I went to the operations assistant. Listen, why did you give this person my number? No, whatever. And I'm like, but this is an operational thing. I don't, it's between you and ops, you know. If only when there's an issue, I'll step in. But if I was to assist and had you had asked for my assistance as opposed to giving my cell phone number.
Is this your personal cell phone?
This is my personal cell phone number that ShopRite is not paying or giving me an allowance for. This is my number, right? Fine, then we had that back and forth. So this specific operations assistant's manager his older brother was the operations manager.
Okay.
Fine, so they're all from head office, which is Cape Town, ShopRite head office, not a problem. So then we have the back and forth. Next moment I'm being called by the older brother and I'm like, no, this is my number. ShopRite does not pay me for this number. So if you are to give away my number, you need my consent.
Of course.
You can give away the landline.
Definitely, yeah.
Landline is ShopRite, so you can give away the landline. Fine, so that didn't go well. Eventually, he took it way up, and then it didn't go well. And then one of the regional managers said, no, I'm behind you, I agree with you. If there's anything, we sort it out at the floor. If it's such an issue overnight, they can come in the morning to HR. Sorted. Happy, fine. But I didn't know that that was the start of everything else. So from then on, everything that I would do, because we reported to the same manager, it would be an issue. Then one moment I'm being called to Centurion for a meeting. It has no agenda. I don't know. It's just a blank email. Hi, Wendy, please join us in Centurion for a meeting at 9. So I then called. So this lady was my peer. She was the head of.
Request or instruction?
It's an email.
Yeah.
In the form of a request. Yeah. Right? So in the morning, I then call and I say, hi, I received your email. I'm looking at it. I don't understand. Did we have a meeting? Did I miss it on my calendar? What is it about? She's like, no, we have a meeting with the regional manager. And then I'm like, okay, but no problem. I don't know about this meeting, you know. And then she's like, no, you need to come through. And okay, cool, no problem. I go there. So I'm guessing this is when they were investigating, right? I go there, I get there, and then they come in with their notepads. And I'm head of department that time, but it's fine. They come in with their notepads. So how's school going? No, school's going great. Oh, you wanted to also register under Stellenbosch for the dispute resolution. Yes. How are you going to do 2 qualifications at once and still work? And I'm like, no, I can. I'm fine. You know, I can do it. And then they were like, no, we heard you making money on TikTok. And I was like, in South Africa? Because this was now 2024-5. Yes. So I think this is when TikTok was only still gaining momentum. So then we went through that. I'm not making money on TikTok. And then we went through my husband's businesses, and we went through how much money he gives me. Yes. Because now we are trying to justify if there's any money coming in that you probably didn't declare. And I don't know how it sort of makes sense, but they were trying to tie. I already understood.
Were you supposed to declare, though, per policy?
It depends, and I'll explain in what instance. So sometimes you'd find that, for example, my husband will send me money from his company. So it will obviously come as PTY something. So now we think you have a side hustle. Do you understand? So obviously in that sense, if it is an issue, then we can get to the part where we discuss that, okay, I'll declare. But if it's not an issue, it doesn't make sense because I don't have any other employment, you know? So then, from then, that's when we touched on that. We went through everything. And then I was like, okay, so am I going to receive an outcome of this? No, it is now an investigation. I was like, oh, okay, cool. They investigated. They did everything they did, issued me with a notice to attend. And I said, okay, I don't understand the charges. No, you'll get to it during the hearing. And I said, it's fine, not a problem. So I did go through the process. So I went through the process normally. Everything was fine. And then obviously, during the hearing, you can always see when, you know, there's an agenda. So I was like, it's fine. Let's just go through the process. Let's appeal. And then let's now start embarking on the CCMA process.
You're scaring
and that's
me.
where we are. Yes. That's where we are.
So from you making a video on TikTok.
Videos
on TikTok.
Yes.
Allegedly, then that becomes a source of income.
So the way that they had started the investigation, especially during the interrogation, right? They first wanted to say I exposed the company's premises, and they told me about the social media policy. And I said, I'm very aware of the social media policy. I know the social media policy. Remember, I started as a consultant. So I used to draft policies. I know, you know. So when they said I exposed the company's premises, I said, yes, I take the videos in my office, but there's nothing that links to Freshmark. There is nothing that links to ShopRite. For as far as I know, these random people in South Africa that I'm advising about their rights don't even know where I work. So then that failed, obviously. Then we had to do what? Go look for some sort of money that ties
Witch
in.
hunt, huh?
Yes, witch hunt.
Yo,
100%.
Man, like, you know, normally I'd go and do a hearing and then issue the outcome, then I'm gone. Right?
That's it.
That's what we do. Right? And to talk to somebody like now, you know, from the other side, like it's an eye opener at the same time. Not to say that, you know, we unsympathetic to employees' submissions. Obviously,
yes. You have to weigh it out. It's a balance of probability. I have to.
And then now, you being the ER consultant who dismisses people, obviously for fair reason, Now you are
Has to
dismissed.
be. You see, the difference with you and certain companies is that with certain companies, they use internal chairpersons. And the internal chairpersons were trained by them.
Of course.
And the decision, they first have to verify whether I can dismiss or not. Do you understand? So that objectiveness is already gone, you know?
Yes.
And I always say to employees that, remember, an employer has every right to dismiss you. Whether it's fair or not, that's what we'll then fight. But it's their right to dismiss. So even if you did nothing wrong, they can dismiss.
They can
and
definitely
then they'll fight
dismiss
it
you.
out, yes.
Wow. Yo, you know what? You and I, your story is... I'm feeling a little bit emotional about it. You know, I never thought normally that an employee relations specialist, you know, can actually go through that process. You know, I mean, I've heard people say, yeah, no, this one is going for a hearing,
Yes.
and.
Yes.
And then you went to CCMA.
Yes, I did. Definitely. That I went to the CCMA even before I was dismissed. So what happened was, after that, that interrogation that I don't know why it was the way it was, I then lodged a grievance, right? To say, I don't even have to know who made this allegation that I'm making money on TikTok, but it's the same person that's been fighting me since I sat in this seat, right? Fine, no problem. I lodged a grievance, and then during the grievance, I'm being forced to take a polygraph test. I'm like, but what is this?
No, man, Wendy, come on.
They're like, if you did nothing wrong, why do you want to take a polygraph test? I'm like, first of all, the CCMA doesn't recognize a polygraph test because it doesn't say whether you did it or not. It just says there's deception or there's no deception. And then the reason why I've opened the grievance, it has nothing to do with why I was interrogated.
No.
It has to do with the allegation that wasn't false. That was false, yes.
Just pause it there.
Yes.
You lodge a grievance.
Yes, after the interrogation.
After the interrogation.
To say the person that has now made this allegation that I'm making money on TikTok is now victimizing me because it was the cell phone number.
Yes.
It was that. So now I'm dating everything that has happened between me and this person. And remember, during the interrogation, they don't tell me who made the allegation.
And then, where does the polygraph test come in?
My point exactly. So, chairperson is dispatched from the Polokwane branch. Now, everything is, you know, that's why I always say to employers, sometimes I prefer you outsource that function. It's best because now if the people, we are all circulating people in the company, we already know what the mandate is. So, fine. Chairperson dispatched from Polokwane, he comes here for a week to chair my grievance. Not a problem. The grievance, then, we don't even discuss what my desired outcomes are.
No way.
Yes.
In a grievance?
In a grievance.
No, that's not a grievance.
That was not a grievance.
No, there's no way you
that
can
was
have
not a
grievance
grievance.
where
Yes,
that outcome is not
100%.
discussed.
And this it gets worse. So the grievance was against two people. It was against the head of department in Centurion, and then it was against this operations manager.
So this is the brothers.
No. So the one brother, it was against him. Then the other one, it was against another lady.
Yeah.
Right? And I knew that they were going to fall into this trap because I knew. So this is what happens. I lodged the grievance with my manager. My manager sends it. So I had two managers. I had a manager in the branch, and then I had a manager nationally. Right? So the manager nationally was on maternity leave. The person that stood in for her was someone that was on my level, that's sitting at Centurion. Fine. So I send the grievance to my manager. My manager sends it to the lady that I've opened the grievance against. And I'm like, but how do you do that? And then he sends me an email, hi, I've sent it to XYZ for advice.
To do what?
How do you get advice by someone I'm telling you is victimizing me?
Oh my.
So obviously I knew by the time it's set down, it's just the tick box exercise. But for me, I was like, then I can then pursue with unfair labor practice because then that's what I wanted. So by the time I referred a matter to the CCMA unfair labor practice, they then speed up everything, dismissal before it can be set down. Yes, they did. They did. Yes.
There's a grievance.
There's a grievance, there's an outcome.
There's a grievance, then there was an outcome.
There's an outcome.
Post-outcome of the grievance.
I refer a matter to the CCMA unfair labor practice. The grievance was not handled properly. It was sent to someone I lodged the grievance against for advice. And during the entire time, she sat in, not as someone who is the aggrieved employee said, you are victimizing me,
Not
but
the
as someone
respondent.
that says I'm representing the company.
No.
Yes.
Not the respondent.
No. So there was a respondent who's the chairperson. She's sitting as HR practically. Yes.
No.
Yes.
How's that
But I've
possible?
opened a grievance against you. How are you sitting as HR?
No, bullshit.
Yes.
Excuse my tongue, my language,
100%.
but I'm getting frustrated at the same time.
100%.
I'm getting frustrated at the same time because
100%.
how do you go to a killer, the person that shot you, and then go and ask them to come and be the judge, essentially?
100%. It's like going to the police station and you're saying, someone shot me. And
Yeah.
they say, go and fetch him and bring him here.
I mean,
You know?
no,
It can't.
no.
So that's exactly how it went. And
is that part of the company policy?
you know, I won't say, when you look at certain companies, right, in terms of how things are structured and the policies that they had and the way they run things, right? So, for example, the first time I stepped into that company, I had an issue with the fact that a chairperson needs to confirm an outcome. That's the first thing that I had.
Confirm with who?
Confirm with the head of department there.
No.
Yes.
Kanti, you and I understand this. The chairperson, they make recommendations.
Yes.
Not the decision.
They make it on, but thing is, even there, the chairperson still has to get an approval for the recommendation they want to make.
So it means that they're not making a unbiased decision. They
It's already
actually
been
their own
decided.
decision as a chairperson because, I mean, chairperson.
They are just there to tick the boxes that I've chaired, I've said this, I've said that, and that's it.
So what you and I are actually saying, and I want to put this on record.
Yes.
It's wrong
It's
for
wrong.
employers to have a chairperson and instruct that chairperson on what to do. Because
100%.
at the end of the day, when you go to CCMA, then what happens?
100%. So there's certain instances though where, especially when I still used to be a consultant, where the employer would say, I don't care what you do, I want this person gone. Then I'll go and draft what? A risk report. That these are the risks you're going to suffer at the CCMA because now you are dismissing this person and substantively there is no basis. It's going to be substantially unfair, right?
I agree.
So that's fine. But now when you look at certain companies, especially with this specific one, with how they run things and how they do things, it is not from that breath, if I could say, where I say I no longer want this person, you know. It's from the thing of we just need to tick all the boxes and that's it, you know.
Well, some companies, they have a budget to
They
fire people unfairly.
They do.
So, I mean, it's something that, I mean, you must be honest. I know that some of my clients might be listening to this or watching this, but it's true. Some companies have millions and millions of rands in budget
100%.
in dealing with those kind of cases.
100%.
And is it fair? Hell no.
It's not fair. It's not
Is
fair.
it a good business decision? It depends.
I mean, if you have budget, I mean, because those are the companies that always only offer neutral reference, nothing else, you
Yeah.
know, because they're okay to travel, they're okay.
Yeah.
And I mean, if you look, it's a big organization. They can afford it, you know.
Yeah.
But for others, if you can't afford it, I'd never advise it.
Wendy, you mentioned something very important, and I want us to talk to both the employers and the employees. If there is a grievance that an employee has opened a grievance against a certain manager in the workplace,
Yes.
do you think it's reasonable or it's fair for a company to, at the same time, do a grievance and charge the employee on the disciplinary side at the same time before dealing with the grievance?
So I would say it all depends, Solomon, right? Because it would depend on what the grievance is about and what you are being charged for, right? If these are two separate incidents, right, they are going to run separately, you know. But if now, let's say, and it also depends on the policy, because you have some companies that say a grievance needs to be resolved within 5 days.
Yes.
Right?
Yes.
So obviously, if the hearing is still not scheduled by then, the grievance will be resolved first, you know. So I think it would depend on whether the grievance is arising from what the misconduct that is on the way, the disciplinary, or are they separate things? If they are, then more or less the grievance are open because of whatever disciplinary processes are underway or have been initiated, you know. That's when then we can sit and say, okay, let's first assess the grievance, because there's some employees that lodge a grievance as a manner of retaliation.
Yes.
Because you're starting your process, I'm also going to start my process, you know. So then I would still say, we follow through with the grievance so that once we get to the CCMA, we've covered all our bases, you know. I can then say, it's fine, 100%, set the grievance down for tomorrow. Let's hear the grievance, because a grievance, it's not that difficult. What's your desired outcome? The moment you start referring to the disciplinary inquiry, then as a chairperson or whoever is then obviously overseeing that grievance can say, no, but then there is a notice to attend. You'll get to defend your side, you know. So if you want to then discuss the disciplinary in the grievance, then this is not the process.
No, it's not the platform.
Yes.
But I normally, personally, always get worried when I have to deal with a case where there is a pending grievance. And mostly where, let's say, an employee lodges a grievance today, then tomorrow a company goes and open a disciplinary case against this employee. It normally looks like it's retaliation, doesn't it?
It does, 100%. And I think sometimes, depending on what the facts are, it could look like a retaliation from either side. Sometimes it could be a retaliation from the employee that, you know, this is what I'm going to do. Or sometimes a retaliation from the employer. Who are you to come lodge a grievance, you know? So then I'll issue you with a notice to attend then, you know? So it depends on the facts. And one thing I love about labor law, on a balance of probabilities, we can always tell which side is probable.
You know, we definitely can. You know, so let's talk to your audience. I want to talk to your people.
Okay.
All right. I want you to talk to your people and my people as well. The importance of lodging a grievance in a workplace, because I believe that employees, they have rights.
Yes.
As far as there is responsibilities, we balance that with the rights.
Yes.
The company has policies that they need to actually abide by.
100%.
They need to live and breathe. As long as a person is within the workplace, they need to live and breathe those policies. So employees, they go through a lot.
Yes.
I must be honest. I must be realistic. As much as I'm pro-employer, I'm pro-employer.
Yes.
That's what I am.
That's your cap.
That's my cap. That's where I come from. That's my history, and I think that's my future. Because I'm also an employer.
Yes,
right?
yes.
So, but the policies are there to guide both sides. So with regards to employees' rights, and based on the grievance, because employees, they go through a lot.
They do.
I mean, I'm just also thinking about this case that I just spoke about of car track. You know, I mean, it's in the news now. I mean, I think that can. Oh, so sorry for disturbing this beautiful podcast. I thought this would be important for you to know and to learn. At Sisol Holdings, we have, you know, we help a lot of employers with labor relation matters, from investigation to disciplinary actions, chairperson to, you know, building company culture and through company policies and procedures. So if you are currently looking to update your company policies, if you have a disciplinary case that is pending and you're looking for investigators or a chairperson, Sisol Labor Project is always here, and it will make sure that you are represented also in the CCMA through the Bargaining Council. So apologies for disturbing. Let's continue with the podcast.
Someone did mention that last night, and I didn't know what it was about.
Yeah, so the case is essentially, allegedly, about an employee who came to work with a headache and they were sick. And they were told, you're not going to go home, allegedly, as per the media, outlets and social media posts. And then the employee went to the bathroom and then they collapsed and they died, unfortunately.
Sure.
May his soul rest in peace.
Oh, so rest in peace.
Such kind of things, when they happen, normally employees feel that they don't have a right. They feel that if they were to open a grievance, they would be a target. What can you talk to the workers about that? I think it's important.
So that is a very difficult one, Solomon. And I think with where I sit at the moment, trying to form a trade union, you know, that's going to have transparency and so forth. Yes.
Man, that will be amazing.
Thank you.
Wow, you are the
so we are
first
trying.
that I'm meeting who wants to start a trade union.
Yes, wow. I'm really trying, because I don't want to meet you after you dismissed. I want to be able to sit with you, since you're with the employer,
What's
and
the
negotiate.
Name of the trade union?
Ahanang Trade Union.
Ahanang.
Yes, I do.
Wow.
Yes.
Do you already have a website?
We do have a website.
Please share the website.
I definitely would.
Yeah.
It's just atu.org.za. Or if you can just say Ahanang Trade Union, it'll pop up on Google. So with what I'm trying to do is that with assisting, there's a lot of things that I've picked up, right? The victimization does happen. There is a case last year that I started where I could see the victimization where when we are supposed to go to the CCMA, they say no leave will be approved in that period, knowing very well that the sit down is that, yes, I'll show you the emails. That has happened.
Any kind of leave.
Annual leave, because remember now to go to the CCMA, that's the only leave that I can take. Do you understand? Annual leave. But then they say during this period, there will be no annual leave that will be approved. But there's no explanation. It has nothing to do with operations. It has nothing to do with the workflow that we're having. Nothing, you know? So the victimization does happen, Solomon. I don't want to lie. It does exist. But what I can say with also what I've noticed is that when employees come to you once they've been dismissed, then they want to backtrack everything the company has done. But you didn't even open one grievance, you know? So 100%, I would say open the grievance, because even if you don't, the employer can still dismiss you, you know? So it's best to rather open the grievance and have something documented so that moving forward, we know that if we have to fight and say, you know what, Solomon denied me sick leave, I could have gone to the doctor and gotten a medical certificate. There's something that you have to say, here is the request that I made, you know? Then you have more documented stuff and you more or less have a trail of a case that you've already built to attempt to fight it. But if now you're going to come to me and you say, for 5 years, this is the abuse I've been going through, the employer owes me money, but why didn't you go to the CCMA 73? No, I thought they were going to victimize me. Then what can we do about it 5 years later, you know?
It's true. You know, I dealt with a grievance easily last week. Number of people who had a grievance against an employee or a manager. But, you know, you realize that people, they bottle things for as long as possible. When that thing comes up and blows out, they completely forgot about the evidence. They completely
now
forgot
there's no
about,
evidence,
about what transpired, when did it happen. Then it becomes a problem for the employer, including the chairperson, to really make a finding.
You can't, because there's no evidence.
Because there's no evidence.
Now you're being charged for negligence. Now you want to tell me last year they were calling you names, you know?
That's exactly the thing. So would you... one other thing that I've observed from my side, that I've observed with the employees is you would want to go into a case and you have, you know, you've been charged with whatever the charge.
Yes.
And you believe that you did not do that. You did not do it. And indeed, sometimes employees, I sit there as a chairperson and I can feel and sense with experience that this person did not really do this. But you look at the evidence, because they come without evidence, including the unions.
Yes.
At the same time.
Bank tables, I've always said that.
They go to the CCMA without any documentary evidence. They expect you as an employer to bring your evidence and share your evidence with them. Then they can use that evidence that you prepared for yourself. I mean, that is. I don't think that is the right way of presenting one's case.
It's definitely not, you know. I always say that things like, for example, the notice to attend, I won't include in our bundle, you know. But with what you've told me that, you know, this started at this date, I sent them an email telling them that, listen, manager, it's going to create a big problem. I want that email, because then the employer is definitely not going to include it in their bundle. So we need that email so that we can have it in our bundle. But your notice to attend, suspension, the employer will obviously bring that. You understand? So I agree with you to say that what we do, and I think I understand 100%, because sometimes one thinks that if I just keep quiet and just keep on working, I'll keep my job, you know, looking at the fact that their unemployment rate is so high, let me just keep quiet. But then there's negligence 2 weeks later. Then you want to tell me about things that happened 3 years back. I didn't say anything, but why did you keep quiet? You know, because now if you're telling me that the company has always had a case against you, but there's no evidence, it's difficult to prove that narrative.
It's also the same as from the employer side, where a manager would remind an employee how many times I protected you. How many times
there's no warning, there's no counseling letter, there's nothing. And then now you want to say they've committed this, dismiss them.
Exactly.
They've done it on 4 counts. Okay, where's the progressive discipline? No, I didn't document it. Then how do we then say, yes, a dismissal is safe?
I fully agree. Let's talk about those employers that personally, I don't like those kind of employers where an employee would work without a contract of employment. And then you come and say that you want to hold an employee accountable for example, working with a cell phone on your table.
Yes.
But you don't have a contract, nor do you have policies to deal with that. What would be your advice to the employees when they join companies mostly? Because I'm of the view that labor relation does not start in a hearing.
It never does.
And a lot of people, they get that wrong.
No, it doesn't. It actually, lately, it starts from the moment an ad is put out,
Love that.
Starts from when an ad is put out. Because if I find that this selection, there's some discrimination,
Yes.
So what I usually say to my audience, right, and they are very adamant about contracts, and I say it depends, If you have an offer letter or you have a pay slip, that is sufficient, But once we start looking at SOPs, like you say, you're not allowed to have a cell phone, rules that are only specific to this specific environment, that's where you're going to have issues, you're right? Because how are you going to prove that this employee was aware? That a cell phone, no, we've talked about it, we have toolbox talks, okay, give me the proof of the toolbox talk where they've all signed and you said no cell phones. No, we just talk about it. Then it's difficult because the employee is 100% going to say, I never knew, but now that you've told me, I'll put it away, So it's very difficult. So what I'd say to them is that if there is a rule that is company specific, have it in the contract, have an induction leaflet where you have all these rules, because I don't think it would be that much, well, a lot, Then from then on, if we look at rules, because there are rules that are not company specific. I don't have to tell you, Solomon, you can't punch someone else, That's clear. Schedule 8 covers it, You should have known that you can't punch someone, If it is not company specific, I think a contract is not necessary as long as you have a pay slip. But if there are rules that are company specific, when you come in work, you need to clock in, you need to breathalyze, then you need company policies and procedures. That's the best thing, because the moment you get to a hearing, the only thing they provide to you is that here's the company policy and procedure, here's the induction leaflet they've signed that they received it, done.
Man, you're going to be dangerous.
Simple.
As a union, I'm really scared for many employers. No, for real. And so you just spoke about something that I'm very passionate about. We have Labor X, which is a labor relations software that we've built.
Oh, wow.
Yeah.
Wow, so that's great.
With the understanding that we have labor relation does not start with the employee's ill discipline. It starts when you hire somebody.
Yes.
It starts when you post, when you actually post an advert online. There's many people that I know who have given up on looking for work. They are completely, they feel like maybe people don't look at their CVs and things like that because they don't get a response. And I remember I had an interview on 702 a couple of years back where I did mention that there is, you as the employer, you need to respond to each and every job application. If you put an advert out there, you need to reject if you reject. Everyone. Failure to communicate. I mean, people invest money. They go to internet cafes. They buy data to try to apply for a job.
100%.
Do employees really understand, in your perspective, and know that they have that right to be treated fairly and equally? I mean, the fact that you in telling somebody that they're successful, isn't it that right supposed to be equally applied to somebody who's rejected at the same time?
100%. I think it's covered under employment equity, right? And what most employers or prospective employers have done is that in the job ad, they'll say, if you have not heard back from us in 3 weeks, consider your application unsuccessful. I'm happy, But those that don't have that and they don't respond, they could be obviously dealing with a case of where if I can prove that Solomon actually doesn't even have an MBA and I have an MBA, so how was the recruitment done? Then we could be looking at some sort of discrimination, right? However, one thing I can say with that also, Solomon, is that there is a case that I'm currently dealing with the city of Tshwane. It's very difficult to prove those cases because in labor law, we don't have a case of corruption, you know?
Yes.
So it's either it's unfair, and if it's unfair, you need to be able to prove that Solomon didn't give me the job because I'm pregnant. You know, he needs to have said it, you understand? But if they just decide to go with Solomon and not me because I'm pregnant and they haven't said it, then that proving it is difficult. But 100%, I agree with you to say employers need to make sure that either you give feedback to all 700 applicants,
Yep.
or in your job ad, you put that the closing date is the 30th of June. If you have not heard back from us on the 1st of August, consider your application unsuccessful.
If you have not heard from us.
Yes.
Also, you know, for me, I personally, you know, with the recruitment agency that we run, I also feel that that could also be dangerous at the same time. Because sometimes positions are extended, the adverts are extended. Now, you don't hear from somebody at this stage, but the advert has been extended. But it's an argument for another day that you and I will have.
Thing is, it becomes so difficult, especially if you don't have like an app that auto rejects. Now you're sitting with 1,500 applicants. You've only selected 5. So what's going to happen to the 1,495? Who's going to reject them?
You gotta put 500
know?
emails. You know, talking about that unfair labor practice, I've dealt with one case. Actually, my sister-in-law, Department of Health, I wouldn't disclose which province, where we won a case of unfair promotion or unfair placement, where they actually took another candidate whom was not favored by the panel. You know, there was, you know, the argument that said that the panel favored this one. So we called the panel to come and testify, and they said, yeah, no, the minutes, they reflect that this one got more.
Was the one that we favored. Then how was it given to?
How is this one then you know, given the position? And we went and I advised her that, you know what, we're going to fight this one.
Yes.
If your story sticks and you have evidence to support that, we are going to fight it. And we went on, we fought it, and we won.
Yes. I think the fact that there was minutes that reflect that she was the preferred candidate, then they would have to have explained how did then the other candidate get this position if already the entire panel was like, this is the preferred candidate.
It makes me think, in your perspective, how important it is to keep minutes of the interviews. Whether you're a big or small organization. Yes,
very important. So I've always said, when I still used to sit on your side, in terms of recruitment and all of that, you know, there is a law where we obviously need to keep data for a set time, right? So I've always said, if you can keep it for 3-5 years, even if you can sort of automate it to then sit on a cloud or something, then after 5 years, it doesn't matter, you know. But as you say, the moment someone comes and makes a certain claim that, you know what, I think I was not offered the position because I am not married, you know, then it becomes a form of discrimination. And how do you address it if you don't have the minutes anymore? You've shredded everything a month ago. How are you then going to say, no, it wasn't because of that? And obviously, you look at the qualification, you look at the experience, everything is the same. Jeez. But they're saying it's because I'm not married.
We're really making things tough for employers, aren't we?
Document. Just document.
That's why it's important to have systems today, you know, as the employer.
Yes.
But let's talk through disciplinary hearings. You know, you share quite a lot around this. Maybe on this platform, the rights of an employee in a disciplinary hearing. Can we cover that?
Yes.
Please share.
Okay, so this is now, I'm trying to tick it off from a notice to attend, because this is what needs to be on the notice to attend and what they either need to be told or needs to be on the notice to attend, right? So they obviously definitely have a right to be charged, you know. I need to know my charges. They need to be clear, right? I was dealing with a client this morning where he said there's no dates on the charges, and I said, okay, you're gonna go and attend, they'll present their side, and then you say, give me an additional 48 hours now that I know we're dealing with January, because if there's no charges, how do I prepare? I don't know which period you're referring to, right? So there needs to be charges, they need to be clear. The employee has a right to present their side of events. They have a right to explain what happened based on the charges. They have a right to cross-question the employer's evidence, you know? So if they're gonna bring Pete as a witness, and Pete was not there when this was happening, you have every right to ask Pete, how are you testifying because you were not even there, you didn't see, so they have that right. They have a right to have the hearing in a language they understand, right? So sometimes you do have employees that say, I can understand English only to communicate, but now since I wanna have my side of events, I would like to speak in Zulu, then the company has to organize an interpreter, And with they're allowed to also bring their own witness. The only issue there is that they need to secure the witness themselves. That's the tough one. And I think more or less, yeah, that's.
Can I get a translator in Sishona? If I want a translator in Shona and I'm from Zimbabwe, for example.
So if the company can organize a Sishona, because most of the time you'd find that it's people, it's other co-colleagues that they work with. Someone will say, yes, 100% I can translate in Sishona. Then yes, you should actually get a translator in Sishona.
I'm actually saying this because I once had a case where the representative attorney said, I want a Shona translator. But I think the Labor Relations Act applies to South African languages, my understanding.
Okay.
My understanding.
Okay.
The 12 official languages that we have, including sign language.
Okay, I would disagree, but yes, go on.
I want you to disagree with me because that was my own opinion, because I believe that in any court, I've never seen in any court in South Africa having a translator speaking Sishona.
You've never?
I've never.
Okay.
I know that Sizulu and our languages that are officially recognized. Also working in South Africa, we would expect that you speak a language in an organization that other people can understand.
Yes, 100%.
If you are the only Shona in the company and now you expect that you get a Shona translator, then it becomes a little bit of an impossible situation to deal with. I don't know if there's any school in South Africa that teaches Sishona as a language.
I also, at that, I can't speak to. I'm not sure if there is. I can't speak to that also. But now, my thing is, I disagree with the fact that South African labor law is meant only for South African languages. Because remember now, there's a process where if you were to hire someone that is not from South Africa through the Department of Labor, that you can embark on.
Definitely.
So then it means that it's open to anyone and everyone. However, I agree with you when you say, if right now the disciplinary inquiry is scheduled for 2:00. We started at 2:00 and you say you need a Sishona interpreter. Like now we have to go around looking for someone that speaks Sishona, which is difficult. And that is why for employers, I used to say, when you issue the notice to attend, when you get to interpreter, find out the language so that you can start looking for someone that speaks this language, so that when the matter is set down, we don't go back and forth now looking for someone that speaks Spanish,
So one other kind of case that I've dealt with recently, based on the rights that you actually just spoke about,
yes,
is the clarity of the charges.
Oh. Employers are killing us with that one.
It's clarity of the charges. I'd agree with you on the issue of dates. A person needs to know as to when did I do this.
Yes.
The allegations.
100%.
When do they happen?
Yes.
Where, when, with who, if possible.
Yes.
And call the relevant, witnesses like you
Yes.
actually just stipulated right now. But on the charges, like in the case law of Avril Elizabeth, it's clear. It talks to say that the charges need not be legalistic.
Yes.
Need not be in a way that a court would expect them to be, because
for a layperson.
Yeah,
Yes.
for a layperson. Would you say that in case where there is a typo in the charges, and I know how important it is to have your charges to be exquisite, clear, even if you don't use the legal language, they must be clear. An employee must understand what they actually are dealing with,
Yes.
what they need to prepare for.
Yes.
But if there's a typo, how do you deal with that?
Well, firstly, as a chairperson, I would ask whether, yes, there is a typo, right? Did you see it? Yes, I did. Does this change your preparation in any way? Do you still understand the charge? No, it doesn't. I still understand the charge. Then we move. You know, because remember now, like you say, and in terms of not having those, if I can say, Latin charges or simple charges, you know, you can just say late for work, you know, poor timekeeping. Okay, poor timekeeping is still fine, but I mean, late for work is fine. Late for work in that on the 6th of October, you're 5 minutes late. Do you understand? That's simple, to the point, done. Now, if the late for work has a typo, or the 6th of August has a typo, the charge, they still understand the charge. They are still prepared for, I was late on the 6th of August.
That is the most important thing. But here's another thing. I'm glad that you and I, we have experience in this. Hands on.
We are aligned.
Right. So there's sometimes you find I've dealt with cases where a trade unionist would come with an employee to come and represent them, and they don't like something. Maybe they don't like how the chairperson smiles. Or maybe they don't like his tie. You know, he's wearing a red tie today. He's definitely going to fire us.
The fact that you said thank you to the respondent, to the company.
Or the fact that you're drinking coffee.
Yes, yeah.
That you've been bribed already. Or you're going to get paid for the services that you render.
Then how are you objective?
How are you objective?
Can't
As
do it
if
for
you
free.
don't get paid by the employee at the same time.
100%.
So, I mean, I've seen trade unionists rocking up and disrupting the process, ending up standing up and leaving the process. And I wouldn't encourage people to do that.
I also wouldn't.
I mean, what would you say to employees who are emotional about a case, or maybe they're angry with their employer, or they see themselves as big and muscular that they can move somebody? How would you advise them to deal with this kind of situation?
So I always say that I understand the emotions, right? Especially if you believe as an employee what the company is doing is unfair, right? There's some form of injustice and it's happening to you, nobody else. I get it, right? However, in terms of being emotional, I call those unions bank tables, you know? We don't, no, honestly, because even when I was like, we're forming a union, I was like, we are not going to bank tables
I'm
here,
going to take
right?
that to work.
Bank tables, because then they get in the hearing, they want to bank tables, you're not going to tell me what to do, but then we're not dealing with the actual reason why we are here. The employee is not getting an opportunity to present their side of events. And if you do stand up and you leave, the company can continue with their disciplinary inquiry, you know, because you were aware, you were there, you made a choice to leave. They can continue. That's it, you know. So what I would advise is that, yes, 100%, and with almost all of my clients that have been with me, they know the moment they come, I've been dismissed, I say, cool, humanitas, counseling, because we're not going to deal with emotions. Once we are set down for arbitration, I need a clear mind, you know, so that once, even if the company starts asking you questions that are personal, that are meant to take you to that emotional, you're able to say, nope, we are focused on the charges, we are here. Anything emotional we'll discuss after, you know. So yes.
I can already see your union being like a matured kind of union.
Yes. You know how employers' organizations are. That's what I'm looking at. The professional, sound mind.
Because I can, you know, I'm saying this because I've dealt with a number of unions, right? A number of bank tables.
Bank tables.
I've dealt with a number of bank tables, and you try to push your legal point, and it doesn't go through.
It won't.
You know, as long as the table is not banged.
Yes. Nothing.
People don't understand.
Yes, yes.
So I'm happy that there's something that is coming. How far are you?
So at the moment, I think the only thing that we are left with, because Department of Labor gave me a long checklist. So we already have the bank account, we've got the name, they didn't have a problem with the name. So the only thing that's left is just that we need to then be able to prove that these members that we have, the subscriptions are going into the bank account, because then we do have an office, we do have the constitution. So everything is already sorted. It's just now proving that in a period of 3 months, the subscriptions are going in and rent is coming out, and we are having meetings. We are actually trying to make sure that the employer and the employee can coexist, you know.
And what's going to be your key value proposition for the South African employees who are currently suffering under certain brands of trade unions, what's going to be your value proposition?
Firstly, transparency. I'm not going to lie to you, it's very difficult to recruit because the first thing employees think of, the employer is going to bribe you, you know? So
Yes.
firstly, it's transparency. Even if there's an email that came through straight to me, the current members that I have, I send it straight into the WhatsApp groups that we've created, that the employer has now proposed this, you know? We'll discuss it during our meetings, but this is what came through. The moment the employer personally phone calls me, I record the phone call and I give it to employees. So the first one would be transparency, and then the second one would be knowledge. The more empowered they am, the less they need me.
Very interesting. And with, I see that there is, there is a plethora of unions in the hence I'm asking you about your value proposition. And I normally see people starting unions coming from the union themselves.
Yes.
Not necessarily coming from HR. Could be somebody who wants to become a president of an ex-union, and they leave, they start their own because now they're disgruntled. Right? So for employers who would be looking at your request or your demand, let's call it a spade. Your demand for organizational rights.
Yes.
What at this current moment is it something that you are currently busy with?
Yes.
And
So
how is that going?
it's a bit tough, I'd say, from a personal level, right? Because the current employers I'm dealing with, some of them are not aware that I've sat on that side, you know? It got to a point where I was like, you can come through, let me show you how public holidays work, so how to calculate it, you know? So that we don't have to keep going back on 73 every month, you understand? Because you're not paying them correctly, you know? So from a personal level, it's very difficult because they're expecting a bank table, and I'm like, no. Go to the section, look at what it says. This is what it says. So now it seems as if I'm undermining, and for me, it's if you know the knowledge, we are no longer going to be arguing about this. We move to better things, you know? So I think that's the only thing that I can say is a bit difficult on a personal level, because then I also do get a bit frustrated, you know? I think to myself, Solomon, how is Solomon sitting there and he doesn't know how to calculate public holidays, you know? But apart from that, I think the fact that we are looking at doing things way different, you know. I was even saying the other day that if we are going to be looking at strikes, we're not going to go to the streets. We're going to strike on social media. We've got more audiences, you know. So imagine if the suppliers start seeing that, you know, there's all these complaints on TikTok, on YouTube about this company not wanting to increase. Yes. So... Why go to the streets? Because then in the streets there's intimidation, there's cops. No, we are all just gonna sit at home and we're just gonna be uploading videos every day, different people, the company, this is what I do, I'm a general worker, they don't want to give me an increase. That's it. Simple.
And you know, thinking about the power dynamics between toy-toying or social media exposure.
Think about it. Because if there's a company sitting in KZN and they're toy-toying in front of the employer's gate, we don't know about it in Gauteng. But if it's on social media, I'd be like,
So are you telling me that you are sort of like a new school digitized union, and your subscription, are you also still using forms?
Well, we do have an online form, but believe it or not, I still do have some members that will say to me, also Wendy, where do I write? I'm like, no, you just go online. We do have so unfortunately, I didn't have a choice. I was like, hey, then we still have to have the manual ones, but we do have a form online that you can 100% complete, and then after that, it's done.
I would encourage South African. I mean, after sitting with you, and with my experience on the other side, I always prefer somebody who would listen to the legal mindset, legal submissions. I'd prefer somebody who would always not to, bow to my command at all times, but at the end of the day, my take of a business is a business is not the name, it's a collaboration of different players.
We're all coexisting. We need each other. You need me, I need you, you know?
Yeah.
So if we can all be aligned to what the law says and there's fairness, we don't even need you and they don't need me.
No,
You know,
of course.
they can coexist on their own, you know.
I'm a firm believer of Sakele Buhlungu, Professor Sakele Buhlungu. I'm not sure whether you read his Paradox of Victory book.
Not yet.
It's one of the books that I read under my undergrad. I think I might have borrowed it to somebody else. I would have,
Hopefully it comes back.
I'd share it with you. But he writes there about the plight of the new employee and the unionism and careerism and things like that. But Wendy, you and I need more time.
We do. We definitely do.
My producer, I see now, he's showing me time to say,
definitely
we are running out of time. See, I'm so sorry. But you know what? There's a lot to talk about, and I'd like us to actually, in the future, once you are up and running, you come back, we talk about your experiences on the field. I hope to meet you one day in the CCMA.
While you sit on that side, definitely. But I think it will be a quick arbitration. We'd get them to settle because we both like, it's here. You did this, it's here.
This is the issue that we've narrowed down.
This is how we solve it.
We're not dealing with all things, right? I wish you all the best. I'd like to really, really wish you all the best. And I want to thank you for coming through.
Thank you for having me.
And I really wish, like, from the bottom of my heart, that you grow, that you mobilize South Africa. And with this new generation that we have in the workforce, you know, we no longer deal with, you know, older generation. There's just new people who believe in tech, who believe in some things to be, you know, to happen quicker than how they used to happen. And I think your idea and what you are pushing is relevant. And I, for one, from the employer side, I think I love it. No, it's not every day where an employer would say, "Oh, union, come," right? But if it's something that makes a business sense, and I think it makes a business sense, and I also think that it makes an economic sense for our people, you know, for my brothers and sisters that are currently watching, who are out there looking for work. Guys, Wendy's here. She will share the contact details. If you are currently on the job market, you are giving up and you are applying, you're not receiving responses, if you've been dismissed unfairly, you no longer need to come to Sisol. We help employers. If you come to me, I'll refer you to Wendy. She will assist you. And I'm very confident based on our conversations, and I think I can vouch for her. And Wendy, I'd like you to share your contact details as to where people can get hold of you. We have quite a lot of followers, mostly from the job seekers.
Yes.
There's about 36,000 to 37,000 followers on TikTok who sometimes need assistance. And I cannot invest my time in the market that I'm really not focusing on. Our market is the employers.
Yes.
Please share contact details.
Thank you. So I can be found on TikTok as the Labor Law Lady. You can send a DM, then our social media will definitely put it through. Alternatively, you can just type on Google Ahanang Trade Union. You can fill in a form and then someone will definitely contact you. And then in terms of my email address, you can definitely also send an email to wendy@ahtu.org.za. And that's it.
Are you the president?
No, I'm the general secretary. I want to be in the field.
The GS.
Yeah, I want to fight.
Wendy, thank you very much.
Thank you for having me.
I appreciate the time. I can't wait to see you again. I'll be following you.
I'll be following you too.
I'll be commenting.
Thank you for having me.
Thank you very much.